Hey everyone, this is Ben from Liable Law. In this video, I'm going to talk about why you need to write a will. Okay, what is a will? A will is a legal document that sets out, gives specific instructions for the distribution of your assets after you die. Now, what happens if you do not have a will? Well, your assets will be distributed in accordance with intestacy laws. You should Google Intestate Succession Act. Essentially, if you are not married, then your assets will be distributed equally between your parents, okay? If you are married but have no children, then half of your assets goes to your spouse, half equally among your parents. If you are married with children, half goes to your spouse, half equally amongst all your children. So this is called intestacy law, meaning die without a will. So why do people do wills? Well, because they want to override the intestacy law. They don't like the intestacy law. For example, a married man may not want to give 50% of his assets to his wife. He may want to give 100% of his assets to his wife. So he does a will to override the intestacy law so that the wife gets 100%, all his assets, instead of 50%. Alternatively, a married man may want to give some to his parents. For example, 25% to each parent, 25% to his wife, the balance equally among all children. Okay? Now let me think. Another possible reason could be, for example, a parent has 4 children. The parent may not want her assets to be distributed equally amongst all 4 children when the parent dies, because one of the children is naughty, is a drug addict, is a bankrupt, okay, or he did something bad. The parent may even want to cut out the son from the estate so that he does not inherit anything. So he does a will and specifically names, he has 4 children, he doesn't like one of them, so he specifically names 3 who can inherit under the will and specifically exclude this one. And this son will not be able to claim against challenge the will or claim against the estate unless he can show he is disabled under the Inheritance Family Provisions Act. Okay. Another scenario would be a parent falling out with his children, so he doesn't want the intestacy laws to apply, so he does a will. Okay. Next example would be LGBT. Now, what is LGBT? If you've been living under a rock, you just Google it. Okay, in the cases of LGBTs, under the law, their partners will not get anything, okay, under intestacy laws. So for LGBTs, what they do is they do up a will so that their partners will inherit part of their estate, part or all of their estate, okay, upon their death. And for some LGBTs who fell out with their parents, they may not even want their parents to inherit, so they may just do a will to give everything to the partners. Okay? Even for married couples, another benefit of doing a will rather than allowing it to go under intestacy laws is that you can appoint guardians under a will. For example, a husband and wife can do a will. The wife says, in the event my husband dies, then I appoint A as the guardian of all my children. The husband then does the same will with the same clause that in the event my wife dies, then I appoint A as a guardian as well. So when both parents die, A becomes the guardian. Okay, now I'm going to talk about the next thing that can be included in the will is funeral arrangements. Okay, Buddhist funeral, Christian funeral. Do you want the ashes to be scattered in the sea, to be placed in a niche? Cremation, burial, these are things which are included in the will. Also, a will allows you to give donations to charitable organizations, which doesn't happen under intestacy law, because under intestacy law it goes to your family. So if you want to give part of your estate to a charitable organization, SPCA, Singapore Cancer Society, can be included in the will. Two items cannot be included in a will. They are CPF, Central Provident Fund, and joint property. Joint property, if you don't know what is joint property, it means property held as joint tenants, okay? For example, two hold a HDB flat as joint tenants. Under the law of joint tenancy, doctrine of survivorship, if one dies, the other automatically gets it. So you cannot give it away under a will. If you want to know more about this concept, you can search for the video I did a few days ago. It's called Property Ownership, Joint Tenants and Tenants in Common. So, there's a misconception that you have to be rich to do a will, but actually that's not true. Even you have one asset like a HDB flat, you should do a will if you do not want it to go under the intestacy laws. Or you may find that you want, for example, an old woman with one HDB flat, one bank account with $2,000. She may not want it to go to her brothers and sisters under intestacy laws. So she may do a will to give everything to her niece. And a will doesn't cost a lot actually. You can do a will for $99. You can even do a will yourself. You don't need a lawyer to do a will. But should you get a lawyer? In my view, yes. Why? Because lawyers are familiar with the law. Let me give you an example. Do you need a lawyer to do a divorce? The answer is no. Can you do a divorce yourself? Yes, you can. You can draft all the divorce papers yourself, file it with court, turn up at court yourself, represent yourself, speak to the judge. Would you do that? Let me ask you another question. Do you need a lawyer to sue someone? No, the answer is no. Can you do it yourself? Yes, you can draft the court documents, go to the court hearings, conduct a trial by yourself even. So, but would you do that if you want to sue someone? The answer is likely to be no. Why? Because the lawyers are trained in the law, they are familiar with the law, they are familiar with wills law, intestacy law, property law, so they are better able to assist you with drafting the will. So that's all I have to say about why you need to draft a will. Thanks for watching this video. Don't forget to click subscribe and like. Thank you.